Hi, I'm Alicia, and this is the top 10 vocabulary words for Washington's family law litigants. Okay, the disclaimer, I'm getting used to saying this. This isn't legal advice, it's general information. In fact, we're very interested in promoting legal literacy for everyone, but especially people who are going to court without a lawyer. This video is not a substitute for speaking with a licensed provider and does not create an attorney-client or legal technician-client relationship or privilege. So communication's a big deal, right? I mean, it's key if you're going to try to get anywhere in dealing with other people. And if it looks like Greek, maybe it is. Or maybe it's legalese written by someone who's a member of a guild that uses language with precision and otherwise might not be intelligible to people who aren't members of that guild. I'll leave that right where it is. So how on earth are you going to make good decisions without understanding what's being said, or more importantly, what is being written? How are you going to sign a proposed order or an order if you don't actually understand what it says? So this is a touch silly, but drum roll, please. The top 10 vocabulary words for family law litigants. Certificate of e-service or proof of service, also known as a POS or acceptance of service. Service is when the opposing party is given the documents that otherwise tell them something's up. And later on in the proceedings, you're going to need to prove that you served the person in the right way and at the right time with the right stuff. This is actually a full-on, often misunderstood area, and there are lots of ways to serve. There are lots of types of service. But if you're in a county that has e-filing, probably the biggest deal for you is a certificate of e-service. It's easy, it's convenient, and if you download it and bring it to court with you, nobody gets to argue with you. Number 9, calendar note, also known as a note for motion hearing or a notice of hearing. This is a document that's filed with the court, and it's quite formal. It's also specific to locations. While we have state level plain language forms, it seems every county has its own calendar note. But let me tell you why it's really handy to download the calendar note from the location or the jurisdiction, the venue that you're after. That helps you prevent mistakes. It helps you not accidentally note something on a Tuesday when the court doesn't hear that something except on Wednesdays and Fridays or that sort of thing. A calendar note is a pleading that sets a date before a judge and tells all the parties to the action when and where to show up. Number 8, continuance. Continuance might be one of the most commonly used words in the unrepresented family law litigant space. It means, can we reschedule this, please? Can I have a little more time? Can I just maybe get a chance to go get a lawyer? A continuance reschedules and delays what's going on, and you can motion for continuance. You can do that with a written motion for continuance, or you can make an oral motion for continuance. Your Honor, I'm here, but I'm not prepared to go forth. I've not yet obtained legal counsel, or I haven't had a chance to respond, or I haven't been served, or whatever it is. A continuance buys you time. Number 7, ER 408. Okay. I know the law's got a bunch of kind of jargon and nomenclature, but this one's worth remembering. Evidence rule number 408 is a protection offered to parties attempting to settle. And to attempt to settle means, come on, let's agree on something here. Let's come to a deal. So we don't have to necessarily ask a judge to hand down a decision for all of us. Let's solve our own problems. The theory behind ER 408 is, as I've come to understand it, the courts really like it when we solve our own problems, and that they'd rather us make our own agreements than have to get involved. And so ER 408 is the evidence rule that if you mark a communication as protected by ER 408, it doesn't get used against you in court. And the idea is that you're incented to make serious efforts, even if you're risking yourself a bit, to come to settlement so we can unclog those courts. If you're afraid that something you're offering in good faith can get used against you, Google ER408 and get to know it. Number 6, response. And reply. Even attorneys sometimes get these two mixed up. But a response is what is sent as an answer to a petition or a moving party's motion, and the reply responds to a response. So it goes motion, response, reply, or sometimes strict reply. And a little funny thing there, if you didn't get a response, you don't get to reply. More on civil procedure another time. Number 5, adequate cause. This is a big deal. Adequate cause is a threshold. It's a gate, and you're either going to get through that gate or you're not. So if you want to modify a parenting plan or a child support order that is less than 2 years old, you're going to have to make a claim, make a motion. You're going to have to bring a motion that there's adequate cause to reopen a final order. There's another catchphrase associated with this, that there's been a significant change of circumstances. We had these orders, Your Honor, and then life changed and something new happened, and therefore we have a significant change of circumstances that creates adequate cause. We don't typically get to reopen final orders, particularly around parenting plans, unless a judge agrees that there's adequate cause to do so. So lots of reading out there on adequate cause. Number 4. Now, you can read this as moving party or moving party, like call up all your friends and get pizzas and move out of your house. No, moving party is the person who noted the motion. The moving party is the person who took the initiative to draft the motion and come to the court and say, I need a calendar note, I need to be heard on something, and therefore the other party, who may be the petitioner or the respondent in the larger case, responds to the movement or the motion of the moving party. And this is helpful when you're reading local rules and they talk about the different parties in a case. Just because you're the petitioner that originally filed a case doesn't mean that you're always the moving party. A hearing is relevant to a motion brought, not necessarily the whole case. And so the moving party is a role that gets played, but it is important to understand, because otherwise some of the local rules that describe the time frames of how things need to be done, and specifically who's going to confirm the hearing, moving party is responsible for certain things. So it's really worth understanding. Number 3. Working copy. Working copies might be one of the most popular ways that unrepresented, or most common ways, I don't think it's popular, one of the most common ways that unrepresented family law litigants fall down and actually don't get heard or have their hearings stricken in ways that they didn't expect and don't understand. Let me put it this way. You can file with the clerk to enter your pleadings into the court's records, but somebody's got to make a copy for the judge who's going to read it and come in and listen to you and hand down a ruling or an order. Working copy is for that judge that's working with you, who needs somebody to make a copy of what's gone to the clerk. And the court basically gives litigants and their attorneys the opportunity and the burden of making working copies for the judge. In King County and e-filing, you can get this done electronically, which is a blessing, but it costs about $23. In some other places, like Snohomish County, working copy may only be submitted in person or by fax, but watch out, gets expensive. $5 a filing plus $1 a page. The big filings can get really gnarly. Number 2, confirmation. Confirmation might be the number one thing that keeps people from getting heard. It's the number one reason that pro ses fall down, and it's something that even attorneys fear. There's a confirmation window in accordance with local rules. And just to drive us all batty, it's different by county by county across our state. But confirmation is a way of saying, listen, we're willing to prepare, we the court, we're willing to prepare a judge to read your stuff and be ready to hear you, but you need to be paying enough attention to this to call in the or to pop online and confirm your hearing. It is the moving party that is responsible to confirm the hearing. And it is the moving party's responsibility to confirm a hearing before the confirmation window closes. If you are 1 minute late for confirmation, guess what? Too bad, so sad. And the number 1 family law litigant vocabulary is both a noun and a verb. This little phrase, uncapitalized and usually used in italics, pro se. The irony here is that most people who act pro se don't know what pro se means. The Latin indicates something like acting on one's behalf, acting for one's self. Both a noun and a verb. If you are going to family law court without a lawyer, you are a pro se. If you are representing yourself in the act of doing so, is to act pro se. Otherwise looks like the word pros with a space in it. A pro se is a person who is not represented by an attorney who is involved in a family law matter and therefore is acting as their own counsel. I'll just give you a little sneak peek. There's an awful lot of phraseology and nomenclature and stuff and acronyms. Here's a little more. Just to give you a sneak peek. There is a special language to the law, but it is not, it is accessible. It takes a little bit of reading and maybe some practice. That's why at My Legal Pit Stop Legal Technicians, we have created something of a family law 101 kind of vocabulary list, and you can download it for free on our website. We'd love to help you help yourself. If you like what we do, please subscribe to our YouTube channel. You could join our mailing list on the website. You could drop us a line or make a comment and let us know if there's a subject you'd like us to cover, and we'll do our best to respond. Thanks for listening. Good luck out there. Bye-bye.